Hello and welcome. Welcome to the Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo. And of course, as always, it's the Red Wagon Estate Planning and Elder Law Show, where we discuss all things estate planning and elder law, and some other things too, right? So today, our topic is going to be about all things wills, last wills and testaments. We're going to talk all about it. What is it? What are some of the requirements? Where should you keep them? Do they get filed? What happens if you move to another state? Among many other things. So as always, just a reminder that you should not take legal advice from this show or any other radio show or podcast. You should seek legal advice from an attorney in the state that you reside to make sure that the advice is correct for your state and your situation. The podcast is meant for informational and educational purposes only, and if you are seeking an attorney in the state of Pennsylvania for anything related to estate planning and elder law, we would certainly be honored to assist you. If you're in another state, please find a certified elder law attorney in your area, and they will be able to help you. All right, so let's talk. What is a will? All right. A will is a document, also known as a last will and testament, and it is a document that says who will get what, when, and how. All right, so who's going to get it? When are they going to get it? How are they going to get it? The person in control after you die, executor if he's male, executrix if she's female, are the people who are going to carry out your wishes. They step in your shoes at the moment of death. Now, that's actually a little misleading. They don't actually step in your shoes until they go to the courthouse, or since COVID, it's been via Zoom, but they do have to fill out a probate petition. They do have to get on the calendar to do the Zoom, and eventually I imagine we'll probably go back to in-person. Currently, at least in York County, we are still doing it via Zoom. So we'll kind of play that out. We are at the end of 2022 as I do this podcast, so I guess time will tell. But when they receive what's called letters testamentary, it's basically just the paperwork from the court or from the Register of Wills office that says, yes, this will was validated, this will is correct. In fact, the executor is, this gentleman or this lady, and we're going to give them the authority to step in the shoes of the testator. As of that day, when the letters testamentary are handed to the executor or executrix, he or she is now in charge. He or she now steps in the shoes of the testator to carry out that person's wishes. All right, so it's at that moment that now they can close out bank accounts. They can start to marshal the assets. They can sell the real estate. They can do whatever it is that they need to do to carry out the wishes of the person who passed away in the will. Now, just to clear up some terms, in the event that there is not a will, then that is called intestate succession, meaning the state has a rule book for you. They have a will for you, and they'll tell you where it goes. They'll tell you who is the administrator. Now, in that context, the administrator is the same as the executor, executrix, or administratrix if she's female, right? Same rules. They have the same fiduciary roles. They have to carry out the wishes of the testator or carry out what is set forth in the intestate succession statute. So you may hear people say administrator or executor. The difference is the administrator is named in intestate succession when there's no will. The executor is who is named in a will. What does a will cover? Well, a will covers anything that is in the person's name alone at the time of the death. So I have a house in my name alone. That goes through probate. I have a house that's joint with my wife. She dies. It transfers automatically to me through non-probate. It does not go through probate. But after she passes, who owns it? I do. And how do I own it? Alone. Therefore, when I die, my family will have to go through probate. So assets can change, right? Depending on who owns it, who's left. But at the time of death, that's when we're going to determine if the asset is in the person's name alone. And assuming there's no beneficiary designation, for example, life insurance, you're going to name a beneficiary. Retirement accounts, you're going to name a beneficiary. Probably annuities, you're going to name a beneficiary. Now, if you don't, and there is no beneficiary listed, then the asset's in your name alone with no beneficiary, therefore it goes through probate. What's probate, may you ask? Okay, good question. Probate is merely the state's rule book by which we carry out your wishes. That's it, right? It's not good. It's not bad. It's not anything other than it is the rules. It is the process. Pennsylvania, if you pay an estimated tax towards inheritance tax, you get a 5% discount. You have to pay it within 90 days of the date of death. We want to file that inheritance tax return within 9 months of the date of death. There are certain notices that are required that we have to provide. Notices to creditors, notices to potential heirs. There's some filings that you have to make. Those are just the rules, right? They're not good. They're not bad. They just are what they are, which is they are the rule book. They are the rules of the state. If you don't want the rules of the state, you have to avoid it. And as I've said on other podcasts, be very careful in avoiding it by just naming an individual outright as a beneficiary. Why? Well, because there's no asset protection. Those assets are now in their name alone, and it didn't avoid inheritance tax, right? Other than life insurance, all other assets are subject to inheritance tax, even if they avoided probate. So sometimes the beneficiary gets the money, and guess what they think? They think it's free and clear, and it might not be. So just be careful with that, okay? All right, so we know what a will is. We know that a will must go through probate, right? That's the whole definition of a will, is that it must go through probate. Once the executor is appointed, he or she then carries out the wishes of the testator. Pretty basic stuff. A will is not filed until death. One of the biggest misconceptions that I hear all the time is, I did a will, it's filed in the court. No, I have heard rumors that Baltimore City used to record wills. I don't have personal proof of that. But regardless, I do know that that is not the rule in Pennsylvania, certainly not now. The only time that the county is going to be aware of your will is at the time of your death. When the executor or executrix takes the will in or prepares the paperwork, submits it, and then does the Zoom meeting, that's the point when the state will file the will and have access to it or put it in the probate file of the decedent where it is a public record and people can go look at it. Okay? Jeff, when I finish my will, where should I keep it? Well, I'm going to tell you a story. Several years ago, I represented a gentleman that I was good friends with, a great human being, and he was taking care of his grandfather. And unfortunately, the children of the grandfather had nothing to do with the grandfather. He became pretty difficult towards the end of his life. He was difficult to handle. He was difficult to talk to. He needed diapers changed. He needed to be brought to a lot of doctor's appointments. The house was a lot. The lawn was a lot. But the grandson didn't care. So he stepped up. He took care of the grandfather for in excess of 5 years. Okay. Lo and behold, Grandpa passes away. Now, in the interim, the grandfather went to his attorney, created a new will, gave everything to the grandson, right? Why? Because the grandson was taking care of him. The grandson was doing all the work. Well, lo and behold, the grandson does submit the will to probate. But somebody else comes behind him and submits a different will that was created before. Right now, normally, always the last standing will applies. There was one problem. What was the problem? Grandson could not find the original will. you need to submit the original will. So we were going to try to prove that, in fact, the grandfather did the will and didn't intentionally get rid of it. But the law sort of says if you can't produce the original, we will assume or presume that you changed it or the testator got rid of it or didn't want that anymore, unless you can prove what happened to the document. All right, so we tried. We tried to prove that neighbors saw his daughter, who used to be the power of attorney, walk into his office or his house, into his office in his house, and came out of the house right after his death with paperwork in her arms and left. All right, now, that's a tough thing to prove, right? We certainly had evidence that she went in. We have evidence that she left with paperwork. We could not prove what it was. We could not prove for sure that it was the will. So ultimately, the 3 children received 100% of the estate. That lesson taught me, without a doubt, that you don't ever want to take a chance on losing the original. So what we do is we file the original in our basement. We built rooms literally in our basement that have fire retardants. We made them as waterproof as possible. We lifted everything off the ground. We have nice shelving systems. It's like a library where the cabinets move in and out and you can place files on the shelves. Beautiful systems. We have 2 beautiful rooms filled with wills and documents in them. Okay. Why? Well, the main reason is because I have written proof in the file that those documents are with me. So if my building burns down, or it floods, or something happens, we can prove what happened to it. I can show the court, I can show the register of will, look, here it is. It was in my possession. Here's proof of the fire, here's proof of the flood, and they will allow us to use a copy because I can show them where it was. In the instance of the grandson, I couldn't prove that the grandfather didn't do a new will. I couldn't prove that he didn't get rid of it so that it went back to the old will, which gave the money to the 3 kids. So my advice, leave it with your lawyer. Let your lawyer be responsible for it. Now, I will admit, from our perspective as the lawyer, I never expected to spend the kind of money that I spent simply to build 2 rooms that could house all of these wills. It has gotten extremely expensive, as you could imagine, but it's the right thing, I believe, for the client. Peace of mind for me, peace of mind for the client. It is still my client's wills. If they die and their executor wants to take it somewhere else, I have no problem with that. We will make sure to get it out of the safe, bring it upstairs, and hand it to the person. Make them sign just acknowledging that they received it, and they can go elsewhere. We're not doing it to keep it hostage or to, make them use us. That is not the intent. It is simply as a service that we provide to ensure that we know where it is at the time that we need it. Okay, so the other comment or question that I get all the time is, well, Jeff, I moved from Arizona. I moved from Pennsylvania. Or I'm sorry, I moved from Florida to Pennsylvania. I have a will from that state. Do I need to do a new one? All right. I used to answer that very, very quickly and say, no, absolutely not. If it was valid in the state that it was created at the time it was created, it is valid in the state that you moved to. Now, notice I said I did or I was past tense, right? So a couple years ago, we had a situation in a local county where there was a will from Arizona. So I had an affidavit of the attorney who drafted the will in Arizona saying this was created in Arizona, and this year I created it. It was valid under the laws of Arizona at the time it was created. We submitted it to the register's office in order to be able to open the estate and to probate it, and a local county told us, no, we will not accept it. Now, I kind of akin that to the phrase of a confused mind says no, right? Whenever you make something confusing for somebody, if it looks different than what they're used to, they're going to say no. Well, it took a while. It took a long while, to be completely honest, where we finally were able to get the will probated, and for the local county to accept it and to allow us to go forward with it. But I learned a very valuable lesson in that instance, because it took us hours and took a lot of arguments and a lot of disagreements and a lot of calls and just, frankly, stress that was undue. We didn't, the person lived in Pennsylvania for a few years, had capacity, could have easily done a new one. So I've sort of changed my position over the years on this one. We're at about 20 years of my career, and so some of my positions have changed slightly from what they were 15, 20 years ago, and this is one of them. What I say to clients now all the time is, look, the probability is it will be completely fine. We will have absolutely no issues, but the truth is I can't guarantee that. A person behind the counter does have discretion, does have subjective intent, and a confused mind always says no. So if you have capacity and you moved, my advice would be get your last will and testament updated into the state that you moved to. Now, we were ultimately able to get that one through, and we have gotten pretty much every other one through that came from another state, but the amount of hassle that we had to go through, in my opinion, was probably not worth it. And when you hire a lawyer and there's a lot of hassle, that generally equates to what? Money, right? So something to think about. Just as an aside, while we're on the topic, I would make a more stronger suggestion of the power of attorney being updated. Powers of attorney are definitely something that could easily be misconstrued, confused. It looks different. No doubt that is something that I would update. If you move, I would get your financial POA updated, and the recommendation is that you get your last will and testament updated as well, out of an abundance of caution, even though you may or may not need to, just for the simple fact that it'll make things a lot easier. The other comment I want to make about wills, a lot of people get their wills done, and you trust the lawyer, you trust the process, you trust what it is that you're doing. And by no means am I suggesting that anyone does anything wrong. But in Pennsylvania, there is something called self-proving of a will. In layman's terms, that means nothing more than I'm going to have a notary notarize the testator's signature as well as notarize the witness signatures, so that the notary is attesting to the fact that she saw both the witnesses and the person signing it witness it, and that, in fact, it is valid. That's a simple way to kind of explain the process, but hopefully you get the point. It's okay if it's not notarized. It's not the law that it has to be notarized, right? But if it's not notarized, not only the testator signature, but also the witness signature, now we need to have people sign basically an oath of a non-subscribing witness to say, yeah, I'm familiar with the signature, and that is their signature, right? Or an oath of subscribing witness saying, yep, I was there, that's my signature, that's their signature, that's definitely them, no doubt. Okay. Is that the end of the world? No, probably not. Does it take time to secure the witnesses, have them take the oath, and sign the paperwork? Sure, right? And depending on where they live, depending on their life, depending on their location, depending on health, right? A lot of things will dictate the speed at which it will be accomplished. So our recommendation is that you make sure you get it done correctly. And we've recently received a ton of wills from other law firms that they did not do it for whatever reason. And it definitely is slowing down the process. And a lot of times when a person passes, everybody wants to move, right? whether it's for selfish reasons of wanting the money or whether it's just the fact that they want to get it behind them, whatever. People are in a hurry when someone dies. So the last thing you want to tell them is, you got to locate these two people who witnessed the signature. And oh, by the way, one of them is an assistant to a lawyer who hasn't worked there in 30 years. And the other one's the lawyer who no one has seen or hasn't been, around. He retired 15 years ago. It just is tough. It just makes it really difficult to find them, to get them to sign. So our advice, get it done. If it doesn't have that correctly, get it redone with that done so that you can avoid the hassle later. I'd like to thank you for joining us on the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo. As a reminder, please don't take any advice that you receive on this show or any other show or podcast for that matter as legal advice. If you're seeking legal advice, please contact an attorney in the state that you live in who specializes in the area that you're looking for so that they can help you. If you're in Pennsylvania, we would love to assist. We are at Belomo & Associates, which is www.belomoassociates.com. Our number is 717-845-5390. Remember, we have weekly workshops. Every week, there are workshops in our York and often in our Lancaster offices, and we can also send a link to you and your loved ones to watch as well. If you get fully educated and you're willing to watch our educational workshops, a team member is willing to meet with you for free to discuss your personal situation. We can't thank you enough for joining us on the Red Wagon and Estate Planning and Elder Law Show. We look forward to seeing you on the next podcast. We hope you are well. Have a wonderful day.